Okay, so at the core here is this matter of what does special solicitude. This is not a term I've ever heard of before, but I ask, how does special solicitude comport with a request for demonstration of under what authority the state engages in actions that violate the Constitution of both the state of Texas and the United States, including and specifically in regards to the treatment of immigrants alongside and in context connected to the treatment of non immigrants. That specific question was put before the court on June 29, 2018. This hearing provides evidence that the state actors leveraged the claims and rights of citizens in order to engage in morally questionable considerations, prioritizing interests associated with and through non citizens. Considerations of moral turpitude have already been invoked in this very opinion. See three considerations regarding memorandum reference for January and February of 2021. If the concerns are regarding conscionability and the performance of contracts, then please see original question put before the court in 2018. Quote, a precedent set by Texas in addressing issues concerning the use of children and minors as derivative instruments for insurance or other purposes is important in addressing other accounting paradigms that are currently under scrutiny at the federal level. The use of parent-child designations regarding accounts for various companies and affiliates provides that the U.S. military command structure uses parent-child command designations, and that the move to classify so much public financing obligation as emergency assistance that would place recipients of recovery under the purview of the Department of Homeland Security calls into question the distinction between civilian and military sectors in U.S. society. Pages 21 to 22 of In Re Charity Colleen Krause, 18-0600, June 29, 2018. So in another matter here, we've got to deal with this concept where he talks about, he says this, the states assert the memorandum will injure two basic interests, their financial interest and their interest as parens patriae in protecting their citizens from this threat, right? And I ask, and then it says here how they would have to spend more on detention facilities and several public benefits and services. And then I quote from what I wrote in my filing that had previously been submitted to the Supreme Court of Texas and then ended up getting attempted for appeal to the Supreme Court of the United States. I say, quote, when one takes into consideration that Krause was able to trace how she was used as a derivative for, and I mentioned the specific kind of company, based on a fraudulent insurance designation, then one is compelled to consider how this is potentially connected to other forms of financial fraud, including other types of insurance fraud that avail themselves of the use of derivatives. An appropriate response to allegations of child abuse at this specific shelter would have impacted access to insurance by the shelter, including and especially if it was found that the cell phone tower was in fact non-compliant with appropriate local code requirements and or that residents were being required to ingest psychotropics unnecessarily, as well as potentially impacting other shelters that use similar modalities. Page 18. Rather than assisting with appropriate reporting procedures, the Houston Police Department obstructed Krause's reporting efforts and other law enforcement engaged in frauds against peace officer bonds. And then I contextualize this by saying, including during a time regarding challenges to local sanctuary cities ordinances and sheriffs that applied the laws under their local jurisdiction. Complaints of fraud concerning bonding and performance of work duties can impact assessments for access to other capital assets. Page 18. And then I reference the sale of the Houston pension obligation bonds by a company, award for housing and urban development agency assistance. These are two of the specific things that were impacted by the financial fraud occurring at the time that was put directly before the Supreme Court of Texas before being put before the Supreme Court of the United States. I said this issue is especially important in considering that Texas is being used to house children of immigrants without addressing how children, including immigrant children, have already been used as derivative financial instruments. To go from one service provider to another while being compelled to perform undisclosed financial services as a derivative is a form of forced labor and qualifies as trafficking according to Texas law. Section 28 Texas Penal Code. In fact, Texas law additionally requires members of law enforcement to receive training and acquire certification in how to address trafficking. Section 1701.258 Texas Occupations Code. Additionally, as was argued in 17-0622 of August 3rd, 2017, assistance from the Federal Emergency Management Agency inculcated previously independent sectors into public services as well as placed them under the rubric of the Department of Homeland Security. Executive Order 13690, establishing a federal flood risk management standard in a process for further soliciting and considering stakeholder input. June 30th, 2015, page 22. That such a decision came as a result of a presidential executive order also calls into question the actual motive behind the executive ban on specific Muslim countries as well as individuals with specific familial relationships. Legal refutations to the ban that seek to justify lifting it based on an inventory of assets available to one without the relational prohibition are evidence of this very point. Pages 23 through 24. The point that in here is that the major problem of consideration here is that these issues had already been put before the Supreme Court of Texas, but were in consideration of an understanding that Texas was being used as a temporary facility, it has temporary facilities within Texas in what was identified as a crisis regarding overcrowding at the border. During a time frame where there was already contestation about how it handled Hurricane Harvey and how, in the course of handling Hurricane Harvey, it used Hurricane Harvey to cover up for other crimes that predated Hurricane Harvey but were exacerbated by and in accordance with the response to Hurricane Harvey. And to sit on those actual allegations, which also entail crimes that were committed during time frames wherein the state was responsible for adhering to its own administrative proceedings policies so that it can then attempt to do for the second time in less than 3 years what it did with its case that it took to the Supreme Court regarding the tax associated, the $0 tax associated with the Affordable Care Act during a specific time period, is evidence that they've intentionally obstructed justice and covered up for crime so that they can leverage it in other scenarios. In this case, under the auspices of some sort of immigration emergency, which is literally making the same points but attempting to, as we will continue to discuss here, when it discusses matters related to, it says here, specifically, the government asserts the states would incur increased financial expenses and exposure to crime only if two conditions are satisfied. Those that otherwise been detained commit crimes or choose to use public benefits and services, or to do so at a higher rate than non-citizens who are removed as a result of the memorandum. And then this is my final comment where I say, I disagree. It is part of a specific scheme, as well as in connection with other specific schemes that have been demonstrated and have already been set in motion and perpetuated due to a failure to address them in regards to due process and equal treatment before the law. This speaks to under what authority were actions that violated the Constitution permitted to supplant the performance of governmental duties, and this then brings into consideration the role of specific commissions in the state of Texas that have been engaging in illegal financial speculation as opposed to performing their constitutional duties, including the two specific commissions which were before Sunset Review on August 6, 2017. If there needs to be a consideration of the Administrative Procedures Act, then this is a place that has been ripe for review and was alleged to be under such administrative procedures and has been alleged to have been reviewed, but was, it now appears, not engaged in good faith and in compliance with the law so as to be made available instead for use later as part of a kickback scheme associated with treatment of illegal aliens as opposed to child citizens and residents. I contend the specific process is demonstrably associated with elements of the racket that appear in the same context and under the same scheme, and would have been provided as evidence in the very scheme that was alleged in the original writ for quo warranto. See today's Federal Register. So if they had actually considered the charges at the time, what they're doing with this case specifically, and in the context of the manners in which they're presenting the arguments, including responding to evidence of the racket being perpetuated by the president, would already have been considered in court and would have already necessitated some kind of relief up to and including criminal prosecution, which then would have rendered inaccessible or unusable the specific scheme that is being applied at this time. And then I say here's it says here when it talks about the states have presented a cognizable injury to their financial interest or interest as parens patriae. And so the court is asking whether the state has done this. And I say the states have committed a cognizable injury to their own people. This and the way that the states are pursuing this case is actually an injury to the people of the state because they refuse to respond to crime is crime as it impacted the state and the people of the state, including citizens of the state or people that were legal immigrants in the state, so that it could leverage those arguments later on at the time they are now, which brings in a question of motive, right? Then he discusses this. They will lose out on federal funds that are distributed on the basis of the state population. And he says that they have. And then I said, would a state commission be considered a third-party interest, as he refers to their concerns regarding third-party interest? According to at least two attorneys general opinions of former attorneys generals who are now in other state and federal government positions, and at least one Supreme Court opinion, a Supreme Court of Texas opinion, they would not be. They would be considered in accordance with the relationship to the legislature as if they were the state, putting considerations of financial injury on third parties as opposed to holding the state accountable for its own malfeasance and crime was the charge first presented in 2017, including before awards for alleged emergency assistance and approval of pension obligation bonds that were affected by the permissibility for the passage of unconstitutional legislation that masqueraded as if it was qualified as a constitutional change, i.e., waiver on the tax of the homestead of the spouse of a first responder killed in action. Without interruption, this pattern has persisted and only increased both the frequency of injury but also the likelihood of further future injury. Now, this was the last comment that I made in the course of this. I've not finished reviewing the entirety of this opinion. Why? Because the next thing he gets to is financial injuries and the allegations these states made of financial injuries. My contention is they have themselves engaged a financial injury. How much time and resources and money that the state could have been applying to actually addressing crime as crime, including holding state actors accountable for their roles in the crime, have they not devoted to that? And that would include the means and manners by which pre-existing claims have exacerbated the situation that has been ongoing with the alleged crisis at the border regarding these relationships with immigrants. I contend, as I have before, that this is actually part of a process where had there been appropriate attention paid to acts of securities fraud, including large-scale securities fraud that were willfully and knowingly engaged, then we would have had a better position to understand what's actually going on at the border. Meanwhile, at this point in time, I had said last week, there is precedent, there is law. I even have the specific process that is reflected as being on the books in the law. Every single bond that is issued in the state of Texas has to be approved through the Office of the Attorney General. And that means that insofar as there is any legitimacy to allegations that this is connected to securities fraud, including fraud involving manipulation of bonds, including bonds for first responders, which I contend that within the last year there have been 3 instances of the governor specifically engaging in frauds against the bonds connected to first responders, as well as securities bonds related to municipalities that may otherwise have been legally engaged in some sort of sanctuary cities process before another act of securities fraud that occurred in 2017 that has material implications for right now, that themselves were used in the course of providing the kind of pressure, if not retaliation, against actual elected law enforcement and others within the state who would have been responding to or involved with some sort of manner in which to address immigration issues, including in consideration of other matters related to processes connected to the health and human services system. That without addressing the securities fraud, that what this actual case is, this is an actual case, and this is an actual opinion by an actual judge, including a judge licensed to practice law with the State Bar of Texas. And this is absolutely evidence of the very crimes that have been obstructed within the state of Texas and on the federal level for going on 4 years. And it is not fair to subject all of the people of Texas and the rest of the country, as well as people that have legitimate asylum claims or have legitimate immigration concerns, to this kind of speculation. If there's problems with the fiscal responsibility of the state, it needs to be handled as it is. not in leveraging and using immigrants or people attempting to apply for immigration as offsets to cover up for those crimes.